national emergency. In India, emergency is of three types: national emergency, state emergency or president's rule, third is financial emergency. 352(2), Article 352 to 360 deals with emergency provisions. Article 352 to 360. Now, we will discuss about national emergency first. Remember, national emergency, state emergency, financial emergency, they should be discussed separately. Don't interlink between one emergency to other emergency. Don't interlink one emergency with other emergency. National emergency is different, state emergency or president's rule is different, and financial emergency is different. There are three types of emergencies. Each emergency should be discussed separately. Each emergency should be discussed separately. In national emergency can be proclaimed when there is a war, external aggression or armed rebellion. When there is a war or external aggression or armed rebellion. If the president is satisfied that there is an occurrence of war or external aggression or armed rebellion, national emergency can be proclaimed. If the president is satisfied that there is no need for actual occurrence of war, there is no need for actual occurrence of war, imminent danger is enough to proclaim emergency. The war need not actually occur. If there is an imminent danger of war, external aggression or armed rebellion, then also president can proclaim emergency, national emergency. National emergency need not be for throughout India. It can be a part of India or it can be throughout India. For example, if the president feels that only few states, few parts in India are threatened or endangered, then the president can proclaim national emergency only for a part of India, not throughout India. Till date, national emergency was proclaimed 3 times. National emergency was proclaimed 3 times. Generally, whenever somebody speaks about national emergency, they think that in India, national emergency was promulgated throughout India only once. Only once throughout India, that is right. But totally national emergency was proclaimed 3 times. And you all know 1975 to 1977, we have national emergency throughout India. After that, when Janata Party came into power, it made 44th Constitutional Amendment 1978. 44th Constitutional Amendment 1978. Through this amendment, many changes were made in the national emergency provisions. Many changes were made in the national emergency provisions. By 44th Amendment, there are many changes in the national emergency provisions. First change is the word internal disturbance, based on which national emergency was proclaimed in 1975, was removed. it was replaced by another word called armed rebellion. It was replaced by another word called armed rebellion. Earlier, before 44th Amendment, war, external aggression, internal disturbance. There is a word called internal disturbance, and the word internal disturbance was removed. The word armed rebellion was introduced. And next thing, the president should not proclaim emergency unless cabinet gives it in writing. Before 44th Amendment, there is no such rule. Prime Minister can ask the president and president can declare emergency. This is what has happened in 1975, June 25th. 1975, June 25th. Most of the cabinet ministers at that time know about national emergency after the emergency was proclaimed. Most of the cabinet ministers at that time came to know about imposition of emergency only after the emergency was proclaimed. This was the condition. So, 44th Amendment made a change in Article 352. National emergency cannot be proclaimed except when Union Cabinet gives it in writing. Union Cabinet should give it in writing, in the written form. The word Union Cabinet, the word cabinet appears only in Article 352. In the entire Indian Constitution, we have the word Council of Ministers, but the word cabinet appears only in Article 352. That too, it was added by 44th Amendment, 1978, because in 1975 emergency was proclaimed unilaterally by the advice of the Prime Minister without consulting cabinet colleagues, without consulting cabinet members. And before 1978 44th Amendment, once the emergency was declared, it can be accepted by the Parliament within 2 months. Once the emergency was declared by the President, it can be accepted by the Parliament within 2 months. Now, this 2 months time period was reduced to 1 month. In case of national emergency, when the emergency was proclaimed by the President, the Parliament has to accept within 30 days. If the Parliament is not in session, within 30 days after it sits in the session, within 30 days after it sits in the session. So, likewise, by 44th Amendment in the year 1978, many changes were made in the provisions of national emergency. By 44th Amendment 1978, many changes were made. Now, listen carefully. National emergency at present can be declared on war, external aggression or armed rebellion. There is no need for actual occurrence of war or external aggression or armed rebellion. Imminent danger is enough. Imminent danger is enough. National emergency need not be for throughout India. It can be for a part of India or throughout India. National emergency need not be for throughout India. It can be for the part of India or throughout India. President shall not proclaim emergency except when Union Cabinet shall give it in writing. Only when Union Cabinet gives in writing, President can proclaim emergency. Once emergency was proclaimed, it should be accepted by the Parliament within 1 month, within 30 days. If the Parliament is not in session, within 30 days after it meets, otherwise the emergency will cease to have an effect. Otherwise, the emergency will cease to have an effect. And President may revoke or amend the provisions of emergency by subsequent proclamation. By subsequent proclamation. And during national emergency, only during national emergency, not in other types of emergencies, fundamental rights can be suspended. Fundamental rights can be suspended. According to Article 359, except Article 20 and 21, remaining all or any fundamental rights can be suspended by a presidential order. Remember carefully. Fundamental rights can be suspended during national emergency. According to Article 359, fundamental rights can be suspended during national emergency except Article 20 and 21. In no case Article 20 and 21 can be suspended. You should not touch Article 20 and Article 21. And according to Article 358, Article 19 will be automatically suspended. Article 19 will be automatic. You don't require a presidential order. For the suspension of Article 19. According to Article 358, Article 19 will be automatic. Remember this carefully. Article 19 will be automatically suspended. As you all know now, on how many grounds emergency can be proclaimed? War, external aggression, armed rebellion. But remember carefully, when a national emergency was proclaimed, according to Article 358, Article 19 will be automatically suspended. Only when the emergency was proclaimed on the grounds of war or external aggression, not on any other ground. No third ground is allowed. Article 19 will be suspended only emergency was proclaimed on war or external aggression, not on internal disturbance, not on armed rebellion, nothing. Only on war or external aggression. Article 19 will be automatically suspended. And one more point, it is not fundamental rights which were suspended, it was the enforceability of fundamental rights. It was not fundamental rights, it was the enforceability of fundamental rights. See, in 1975 on June 25th, 1975 June 25th, national emergency was proclaimed. Within 2 days, on June 27th, I remember, on June 27th, 1975, there was a presidential order on suspension of fundamental rights. In this scenario, you should understand few things. There was strict censorship of press, heavy use, complete usage of MISA, Maintenance of Internal Security Act, PD laws, preventive detention laws were used. Opposition was completely controlled, and there were lot many detentions during emergency, national emergency, and by President's order, even habeas corpus petitions are invalidated. In this scenario, there was a case, very controversial case in the national emergency cases. Without this case, there is no national emergency article. Very, very important case. You have to explain this. Now I will explain to you in detail. You have to explain this in the exam. The case is ADM Jabalpur versus Shivkant Shukla. ADM Jabalpur versus Shivkant Shukla, 1975. Never forget this case. Whenever you are reading about national emergency, ADM Jabalpur versus Shivkant Shukla is very, very important. Listen to the background of the case and the case. As you all know, the Allahabad High Court declared Indira Gandhi's election from Rai Bareli was unconstitutional in 1975. Indira Gandhi's election from Rai Bareli was declared as unconstitutional. Yesterday in basic structure theory we have discussed rule of law and free and fair elections. After this declaration by the High Court, Indira Gandhi approached the Supreme Court and she got a stay. After that, on the ground of internal disturbance, emergency was imposed throughout India. And after emergency was imposed, on June 25th, on June 27th, a presidential order was made. On June 27th, a presidential order was made. No writ of habeas corpus, no writ of habeas corpus would be maintainable against any arrest or detention. No writ of habeas corpus would be maintainable against any arrest or detention. This was the presidential order. What is habeas corpus? To produce the body. That means that during national emergency, at this time in 1975, the government can arrest or detain any person and put him in jail. You cannot file a habeas corpus petition. This was the order given by the president. This was the order given by the president. No habeas corpus, no petition should be entertained by the court. And many people were arrested and detained under many laws, preventive detention acts like MISA. Journalists were arrested, opponents were arrested, many arrests and detentions were made. For no reason opponents were arrested sometimes. All these things were made during emergency. Then 9 high courts in India said habeas corpus petitions can be maintained even during emergency. 9 high courts in India said habeas corpus petitions can be maintained even during emergency. That means even emergency cases, the basic right of citizen to produce a body, to have your own body, not to get illegal arrest, was allowed even during emergency. This was a judgment given by 9 high courts in India, and government went on appeal against the judgments of 9 high courts. Government went on appeal against the judgment of 9 high courts. And then what happened? There were 5 judges in the Supreme Court. There were 5 judges. Justice Chandrachud, Justice Bhagwati, Justice A.N. Ray, Justice Beg, Justice H.R. Khanna. There are 5 judges. Out of 5 judges constitutional bench, 4 judges, Justice Beg, Justice Chandrachud, Justice Ray, Justice Bhagwati, said that no habeas corpus petition can lie. No habeas corpus petition can lie during national emergency. You cannot claim your civil liberties. You cannot claim your habeas corpus during national emergency. The dissenting judge, only one judge, H.R. Khanna said, even during emergency habeas corpus petitions lie. But the majority judges, 4 judges said habeas corpus petitions cannot be valid during national emergency. This judgment is the most debatable and most controversial judgment during national emergency, where a constitutional bench strongly declared that under emergency no one could seek the assistance of any court. Under emergency no one could seek the assistance of any court in India to try and save his liberty, if it is taken away by the state. This is the serious case of, important case of ADM Jabalpur versus Shivkant Shukla. Okay. So, this case is a glaring example of how the judiciary have interpreted the order in letter but not in its spirit. The presidential order says no habeas corpus. The spirit of personal liberty, the spirit of constitutional freedoms were not taken into light. Only literal interpretation of law was taken. So, this judgment, many experts say it is not correct. This is called ADM Jabalpur versus Shivkant Shukla or habeas corpus case 1975. Without this case, there is no answer of national emergency. And remember, during national emergency, Article 359 says fundamental rights, any or all except 20 and 21 can be suspended by a presidential order. According to Article 358, the enforceability of Article 19 will be automatically suspended. The enforceability of Article 19 will be automatically suspended when the emergency was declared on war or external aggression, and any actions, commissions or omissions done by the government violative of Article 19 will be valid during emergency and they will cease to have effect after 6 months after the emergency. Anything done against Article 19 by the government during national emergency are valid, and they are valid up to 6 months after emergency. After that they will become invalidated. And the life of Lok Sabha can be extended for 1 year at a time. The life of Lok Sabha can be extended for 1 year at a time. Article 83 clause 2. During national emergency, what is the normal life of Lok Sabha? Maximum 5 years. During national emergency, the life of Lok Sabha can be extended for 1 year at a time. It can be extended for any number of times. And remember, when national emergency was proclaimed and approved by the parliament, it is valid for 6 months, and for every 6 months it should be approved by the parliament. There is no maximum time limit for national emergency. Okay. So, life of Lok Sabha according to 83 clause 2 can be extended for 1 year at a time during national emergency. According to Article 250, Parliament can make law in the state list during national emergency. During national emergency, generally in the state list, state legislature should make the law, but during national emergency, Parliament can make law in the state list. Article 250, and Parliament can make law in the state list according to Article 250. The centre can give such directions to the states during national emergency. The center is empowered to give directions to the state during national emergency. If you see Article 353, the executive power of the union shall extend to give directions to the states during national emergency. Article 353, the executive power of the state shall extend to give directions to the state during national emergency. And Article 354, the President may direct certain financial and revenue distributions to be done in accordance with certain presidential orders. So, Article 353, executive directions can be given by the union to the states. There can be some applications of provisions relating to the distribution of revenues between center and the states. So, whenever you are writing answer on national emergency, you have to mention Article 352, Article 83 clause 2, Article 250, Article 358, Article 359 and Article 353, Article 354. Article 354. And can Lok Sabha is empowered to withdraw the emergency, to lift the emergency? Yes. That too, see, emergency when it is imposed by the president, it should be accepted by the parliament within 1 month. 2/3 majority present and voting. This 2/3 should be the absolute strength of the house, should accept. The acceptance of emergency is very difficult, but withdrawal of emergency, lifting of emergency is very easy. 1/10 of the members of Lok Sabha, 1/10 of the members of Lok Sabha should give a notice if the house is in session to the speaker, if the house is not in session to the president. One session to the speaker, if the house is not in session to the president. Within 14 days, a special session should be conducted. Within 14 days, a special session should be conducted. If you see Article 352 clause 8, you will understand. Within 14 days, a special session should be conducted, and Lok Sabha can disapprove it, House of People can disapprove it by a simple majority. House of People can disapprove it by a simple majority. This was really important. So, imposition of national emergency is a tough task. Removal of national emergency is a easy task.